Ready? 3, 2, 1, start. It is thus clear from a reading of Section 31 that upon a breach being committed by an industrial concern in any repayment of the loan or any installment thereof, or where the financial corporation requires an industrial concern to make immediate repayment of any loan or advance under Section 30 and the industrial concern fails to make such payment, then it may apply to the district judge for one or more of the following reliefs, namely for enforcing the liability of any surety. Stop para. This would clearly indicate that even for enforcing the liability of a surety, the right to apply arises upon the breach being committed by the industrial concern in paying any installment, or the corporation requires the industrial concern to make immediate repayment of any loan under Section 30 and the industrial concern fails to make such repayment. Stop. In this case, both these conditions are satisfied in as much as there is a breach committed by the industrial concern, the company herein, in paying the installment, in as much payment of all the installments are defaulted. Stop. Secondly, the corporation has called upon the industrial concern to make the repayment by issuing a notice during the year 1987 itself. Stop. Thus, therefore, even according to the statutory prescription laid down under Section 31, the right to proceed against the surety for enforcing the liability of the surety has arisen upon the breach being committed by the loaner in paying the installment, or when the corporation required, or when the corporation called upon the company to make the payment of the loan amount by issuing notice in the year 1987. Stop. The legal position regarding the application of Article 137 of the Limitation Act is held in favor of the corporation by the decision of the full bench. Stop. That being the position, the right to apply against the surety having accrued at least latest by January 14, 1987, the petition ought to have been filed within 3 years from the said date on or before January 14, 1990. Stop. But the petition is filed in the instant case in the year 1994. Stop. Therefore, the only irresistible conclusion that is possible under the facts and circumstances of this case, and having regard to the foregoing discussion, made on point number 1 is that the proceedings initiated by the respondent corporation for issue of the recovery certificate are clearly barred as per Article 137 of the Limitation Act. Stop over.